Viewers, Namaskar. I welcome you to the presentation on selected judgments happening between 15th of March to 31st March 2026. I sincerely hope you will like the presentation because there are many dynamic cases in this. Having said that, today as I was seeing, I found that there are about 2,618 topics in the website, which really shows how intelligent human beings are and the diversity of thinking, which has enabled us to compile 2,618 topics, and it's growing every day. So, keeping in view this factor, I would strongly recommend all my viewers to every day check the website and see new cases which are coming, because it's not possible to assimilate all the new topics in the podcast, because then in such case the podcast will be very, very long. So with this, I take you over to the main presentation.
We are on the screen of, or rather we are on the dashboard of Section 5 of Insolvency Bankruptcy Code. Section 5, as you know, is the section pertaining to definitions, Section 3 and Section 5. Now we are coming to subsection 5A, which deals with corporate guarantor. Now, before starting this, I would like to say that I have to my credit another 1.5 years to continue as insolvency professional. I'll be reaching 70. Of course, I propose to pursue this research beyond that, and I would like to have somebody to carry on my legacy. But my basic motto is to tell you whatever I have learned in the course of being an insolvency professional and by doing this research. So often I deviate from Insolvency Bankruptcy Code and take you to judgments which are not directly linked to Insolvency Bankruptcy Code, but gives us some lessons to learn. So, and this is going to be a case something like that. So before doing that, let us understand what is 5A. 5A says, corporate guarantor means a corporate person who is surety in a contract of guarantee to a corporate debtor. Understood? We are coming to topic number 6. To constitute a valid guarantee, the requirement is an undertaking of promise to make a payment to the creditor upon the default of the principal debtor for a benefit received by the principal debtor. So who gets the benefit? Principal debtor, not the corporate guarantor. The cases of Canara Bank Overseas Branch versus Archean Industries Private Limited, Civil Appeals to Supreme Court. It's a very recent judgment. The judgment, as I said, doesn't deal with Insolvency Bankruptcy Code, but gives an in-depth knowledge of what a guarantee is and how the guarantee operates. And the judgment, if you go through the judgment, you will see it has touched upon Section 126, 127, 128, 137, 138, 140, 141 of Contract Act 1872. And all these are very important. And in general, this is an excellent read because it gives you an idea, though it is not concerning Insolvency Bankruptcy Code, but it gives you an idea as to how the guarantee operates and how does it, and guarantee is something which is an insignificant part of now insolvency bankruptcy process. Now with this, I stop the screen share here and take you to the slide which I prepared for you. Now, important takeaways from the judgment is what? A contract of guarantee is an undertaking to perform the promise or discharge the liability of a third person in case of his default. It is essentially a voluntary act of taking up the burden of a third party who has received or is about to receive some benefit and has failed to make the payment. So this is possibly the only type of contract where there is no consideration. This is a voluntary act of taking up the responsibility or the burden of a third party who has received or is likely to receive a benefit for which he is supposed to render payment, which and he has not. A guarantor is called a surety, and the person in default. And person in default is called the principal debtor. It is not necessary for the guarantor to derive any benefit from the transaction. It is sufficient if the principal debtor derives the benefit. We know that. The guarantor is in itself the guarantee is in itself a separate contract and enforceable independently. And the liability of the surety is coextensive with that of the principal debtor unless otherwise provided by the contract. This we know so well. We have read it in Lalit Jain and others. Lalit Jain judgment and so many others. The creditor proceeds to recover only from the surety. The surety is at liberty to recover the same from the principal debtor, as he would have stepped into the shoes of the original creditor by virtue of doctrine of subrogation. Means what? If the creditor receives the money from the guarantor, in such case, what happens? The guarantor becomes the creditor, and he has every right under the doctrine of subrogation to recover it from the principal debtor. That is automatic. The creditor is entitled to proceeds against the surety without first exhausting remedies against the principal debtor. This also we know. To constitute a valid guarantee, the requirement is an undertaking or promise to make payment to the creditor upon default of the principal debtor for a benefit received by the principal debtor. These are all consequential to a guarantee. A plaintiff cannot ordinarily be compelled to sue a person against whom he does not seek any relief, unless such person is shown to be a necessary party whose presence is indispensable and for the effective adjudication of dispute. A defendant can claim contribution or indemnity from a third party or even the co-defendant by issuing a third-party notice. A plaintiff cannot be compelled to implead a third party unless such party is shown to be a necessary party without whose presence the dispute cannot be effectively adjudicated. So this is an excellent judgment. And I would recommend all my viewers to please go through this. And with this, I take you over to the next slide. We are now on the screen of Section 12A of Insolvency Bankruptcy Code on Guide to IBC website. Section 12A deals with withdrawal of application admitted under Section 7, 9 of 10. We are mostly aware of Section 12A, so I'm not going into it. We are straight coming to topic number 52, which says that the court cannot be called upon to sit over the comparative financial attractiveness of rival offers or substitute its own view for the business decision taken by COC in the statutory process under IBC. The court cannot be called upon to sit over the comparative financial attractiveness of rival offers or to substitute its own value view for the business decision taken by COC in the statutory process under IBC. This case is of Messrs. Lamba Exports Private Limited versus Messrs. Dhir Global Industries Private Limited, miscellaneous application, Supreme Court 2025. This is possibly the judgment of 23/3/2025, 26. I'm sorry. This case essentially deals with, to bring it in a nutshell, there was a company which had entered into which was likely to sell a property at 21 crores. It had got, it was selling, so it had deposited rupees 30 lakhs as earnest money. It had received and 1.2 crore to back. It had submitted towards OTS proposal, which it had given. Then subsequently the buyers was backing up. The respondents concerning and the party went in for specific performance. But in the meanwhile, IBC proceeding was moved, and there was a question of withdrawal of IBC CIRP proceeding under 12A. And definitely the party came to, there was a Supreme Court had issued an order on this particular case, and the court came, and this party came to reverse the order with a request to Supreme Court to reverse the order it had given in an SLP on a special leave petition. So on this, the entire case is built. So this is an interesting read. This is not the usual 12A petition, 12A matter which we get. So I would request my viewers to please go through this. So not further dwelling on this, let me take you over to the slide which I prepared for you. Order dated 25/2/2025, recall of which is sought, is not an executory order. It merely records that this court was not inclined to interfere with the impugned judgment and order of, and accordingly dismissed the SLP. It was not an executory order. It was just that the court did not want to interfere with the impugned judgment and the order and accordingly dismissed the SLP. Once a matter stands disposed of, the court becomes functus officio and does not retain jurisdiction to entertain an application except in narrow situations recognized by the law. Once a petition SLP or any matter is disposed of, court becomes functus officio. It is no more involved with that and with the order. And it does not retain jurisdiction to entertain the application except a few exceptions which are legally recognizable. The SLP arose from a suit based on dispute concerning agreement for sale dated 13/8/2021 and the correctness of the order passed by High Court in civil revision number so and so. The present MA seeks to found a case for recall based on the later development said to have taken place in the insolvency proceedings, including the proposal of OTS and the order passed by NCLT under Section 12A of IBC. A later event may, in a given case, furnish an independent cause of action. It cannot by itself be used to reopen finality in proceedings in a different character and origin. This is absolutely a technical matter. The Section 12A petition is an altogether independent court action. It cannot by itself be used to reopen an order of Supreme Court which has attained finality. The statutory scheme of 12A of IBC contemplates withdrawal of insolvency process after constitution of COC only upon approval by requisite voting share of COC. We know the 90% voting share is required. Once the matter enters the domain, the decision whether to accept the settlement or whether to continue with the process, whether to adopt one commercial course over the another, falls essentially within the realm of collective commercial wisdom of states. Obviously, the legislature has consciously made commercial wisdom of financial creditor non-justiciable, and that adjudicating and appellate authorities do not sit in appeal over such business decisions. We all know that. Where a withdrawal under 12A of IBC has been received, the requisite approval, where a withdrawal under Section 12A of IBC has received this requisite approval, the scope of interference remains narrow, and the commercial decision of COC is not to be displaced except on grounds known to law. So if there has been no apparent violation of law, then why the court should enter into it? The court cannot be called upon to sit over the comparative financial attractiveness of rival offers or to substitute its own view for the business decision taken by COC in the statutory process under IBC. The present MA is as a vehicle either for reopening the dismissal of SLP dated 25/2/25 or for examining the legality of the subsequent steps taken in which insolvency proceeding cannot be entertained. This is absolutely impossible. So this is a different case as far as 12A is concerned, and Supreme Court came heavily on this. And the basic idea is frivolous petitions to be avoided. And a matter like this should not have reached Supreme Court. So this is of importance, and for the first time, not for the first time, it is known that commercial wisdom of COCs cannot be challenged. It's not justiciable. But in 12A, the Supreme Court has categorically stated that a decision taken by COC, which is not ultravirus the law, apparently, court will not entertain court does not retain any jurisdiction to enter into it. So with this, we move on to the next slide. On the screen of dashboard of topics coming under section 14 of Insolvency Bankruptcy Code. As we know that section 14 on initiation of CIRP, the NCLT or the Honorable Adjudicating Authority imposes a moratorium, which runs from the commencement of CIRP date till the date when the resolution plan is passed under section 31, or a liquidation is ordered under section 33. Now, we have seen in multiple cases there is problem with electricity provider, or rather, why electricity provider? Any utility service provider. Invariably they ignore, and the complications arise. Many cases have taken place in which has been adjudged in NCLT, even in Supreme Court. So recently, there has been a judgment of Supreme Court, which I'm going to deal. The topic is security deposit given by a corporate debtor to electricity supplier or other bodies cannot be unilaterally adjusted. The cases of Central Transmission Utility of India Limited versus Sumit Binani and others, Civil Appeal so and so, 2025. This is a very recent judgment. The topic is, the case is quite, it's an elaborate judgment of Supreme Court. In this, what happened, while the CIRP was in progress, it was regarding Mahanadi, KSP Mahanadi Projects Limited, which was under CIRP. They had, since they could not place a letter of credit, or bank guarantee, the company had provided a fixed deposit. Company had provided a deposit of 104 crores. 104 or 140 crores. Amount of 108.44 crores. I'm sorry. And which was for adjustment of whatever default is there. But despite that, this is an asset of corporate which they cannot adjust during existence of moratorium. Whereas in this case, this power service provider adjusted it. So the entire case deals with this particular thing, and this is being a Supreme Court judgment, this is very important. So I would rather, while recommending that, please go through the excerpts of the judgment that's featuring on the website. It's a very interesting read. Let me take you to the slide which I prepared for you. What does the judgment say? KNPCL entered into a bulk power transmission agreement with PGCIL, later substituted by Appellant, that is Central Transmission Utility India Limited, for obtaining long-term access to the interstate transmission system. TSA was executed with the appellant, and consequent PPA was also executed. What is PPA? Power Purchase Agreement. The amount of rupees 108.44 crores is deposited with the appellant in lieu of LOC, which is a security for due payment of bills raised by the appellant during the validity of the period of TSA. So, transmission system agreement, during validity, this was a security deposit. On 3/10/2019, NCLT, Adjudicating Authority, passed an order of CIRP against CB, which is the insolvency commencement date. The applicant had raised claim under Form B thrice on 3/1/20, 9/7/21, and 12/10/2020, a portion of which was admitted by RP, which which limited acceptance was not challenged. A portion of the claim was adjusted. After commencement of the insolvency proceeding, a claim which is submitted in Form B on 3/1/2020 of 356.41 crores, of which 96.70 crores was admitted by RP. The amount now apportioned to pre-CRP dues, hence was claimed before the RP. Form B was again filed twice on 9/7/2021 and 12/10/20 after the apportionment on 18/3/2020. That means 97, that is 96.70 crores, was adjusted from 108.44 crores. And then Central Transmission Utility India Limited submitted another claim, adjusting that, which RP did not accept and RP protested it. There was no debt due from CD, on account of which set-off could have been made by the appellant of the dues arising on default of payment of monthly dividends. It was found that statutory set-off under Order 8 of Rule 6 of CPC or insolvency set-off is permitted under by Regulation 29 of liquidation regulations, cannot be applied to CIRP. We know the Regulation 29 in the liquidation regulations and the set-off. During CIRP, this is not accepted. During CIRP, no set-off is accepted. If you remember, I had mentioned pre-admission of COC, pre-admission of CIRP, the set-off can be allowed. Post-admission, no set-off is allowed. Again, when it comes into liquidation, set-off can be considered. Set-off under Regulation 29 can be considered. The set-off would mitigate against the pari passu principle, which is apparent from the scheme of IBC. Subsequently, the apportionment was made unilaterally. The pre-CRP dues from the deposit clearly violates the moratorium. I mean, during moratorium, nobody is allowed to make such adjustment, because this depletes the assets of the corporate debtor. The NCLT approved the resolution plan, and the same is implemented, which was not challenged by the appellant. The resolution plan was approved, and the same was not challenged by the appellant. The IM prepared by RP, which discloses rupees 108.44 crores in the balance sheet, is under asset and liabilities of the CD, is an asset, and later, after information as to its apportionment, is a disputed issue pending before NCLT. So in IM, RP had mentioned that 108.44 crore is an asset of in the balance sheet. They mentioned the assets of that in the IM. Now, resolution plan is also approved. Now, if you adjust a portion of 96, then 108.44 is not there. So the resolution plan gets vitiated, which is not permissible. The NCLT and NCLAT have rightly found that the apportionment made by the appellant to be violative of provisions of IBC and is in derogation of the moratorium under Section 14. So this was definitely not permissible. So this being a Supreme Court judgment, we have seen similar judgments, but this being a Supreme Court judgment, this actually attains a new level, and now it becomes a set of laws, a set of law pertaining to Section 14 with respect to utility service provider, and hopefully they will understand and they will follow this. So with this, we move over to the next slide. Viewers, we are on the screen of Section 14 of Insolvency Bankruptcy Code. What does Section 14 say? Moratorium, which is declared at the time of declaring CIRP proceedings, CIRP process. At the inception of CIRP, moratorium is declared by NCLT or Honorable Adjudicating Authority. Now, the topic which we are going to deal with is topic number 26, which says that if a penalty is imposed or demand is raised by any statutory body, it may be claimed as an operational creditor, but cannot be recovered during the resolution process. Clear? Now, this particular case which we are going to deal with also deals with Section 238. And the heading is, in case of conflict of any statute with the provisions of IBC, the court shall override SEBI circulars provisions, provisions of the Securities Contract Regulation Act 1956 and the Security Exchange Board of India 1992. Let me read it out again. In case of conflict of any statute with the provisions of the code, the court shall override SEBI circulars, provisions of the Securities Contract Regulation Act 1956, Security Exchange Board of India 1992. I personally feel that you should also have an idea of, let me take you over to Adjudicating Authority 60 and 60 subsection 5. Subsection 5 says that notwithstanding anything to the contrary contained in any other law, for the time being in force, the National Company Law Tribunal shall have jurisdiction to entertain or dispose of A, any application or proceeding by or against the corporate debtor or corporate person. B, any claim made by or against corporate debtor or corporate person, including claims by or against any of its subsidiaries situated in India. And C, any question of priorities or any question of law or facts arising out of or in relation to insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under this code. That means Section 60, subsection 5 gives it a wide jurisdiction to deal with any matter concerning Insolvency Bankruptcy Code in concern with CIRP and liquidation process. This too comes with a non-obstant clause, similar to Section 238. So the case we are going to come to is, let us come to 26. We have already had, this is, BAC Limited versus Mr. Avil Manzes and others, Company Appeal so-and-so, 2025. BAC Limited versus Avil Manzes. Now, in this case, what happened was, BAC, that is Bombay Stock Exchange, froze the account of the corporate debtor on the ground that they had not paid annual fees, and accordingly the account was frozen. The company had shares in the account, tradable shares in the account, and obviously the CIRP proceeding, the RP could not take possession of the assets. Since the account was frozen, he could not trade or he could not take possession, which is permissible under Section 18 of Insolvency Bankruptcy Code. And thus, he moved a petition before NCLT, and NCLT defroze the embargo imposed by, or the embargo imposed by SEBI. So with this, this is a long judgment. It's a 75-page long judgment. So in order to make it short and understandable, let me take you over to the slide which I've prepared for you. The adjudicating authority has defroze or defreezed the demat account of CD, which was freezed by appellant, that is BAC Limited, on account of non-payment of annual listing fees by CD, which I've already told you. So far as the shares lying in those demat accounts are concerned, were owned by respective CDs, and this fact has not been denied by appellant. When CIRP has been initiated for recovering any amount, the claim has to be filed and no recovery can be made since moratorium has been imposed under the code. When the IRP is duty-bound to take control and custody of assets of corporate debtor, application under Section 60, subsection 5 with subclause C was certainly maintainable. I've already read Section 60, subsection 5 for you. And a petition by RP was certainly maintainable. It is clear that the moratorium provision contained in Section 14 of IBC would apply only in the case of only to corporate debtor. You must be remembering P. Mohan Raj case. In the case of conflict of any statute with the provisions of IBC, the court shall override SEBI circulars, provisions of Securities Contract Regulation Act 1956 and Security Exchange Board of India 1992. This is by dint of Section 60, subsection 5, and read with Section 238. The directions of the authorities to freeze the accounts of CD during liquidation of CIP process are bad in law, and it was within the jurisdiction of the adjudicating authority to issue appropriate direction providing statutory relief to the appellants. Section 14 of the Code will prevail over 228A of SEBI Act 1992, and Security Exchange Board of India cannot recover any amount, including penalty from the corporate debtor. Obviously, because it violates Section 14. The statutory dues, that is, dues of central government or state government, arising under the law for the time being in force and payable, come within the meaning of operational debt. So we know what is operational debt, and we know the Section 5, subsection 20 and 21 includes debts from dues from central government and state government also. If penalty is imposed or amount is payable to Security Exchange Board of India, that is SEBI, in such case it may claim as an operational creditor but cannot recover the same during the resolution process. The non-obstante clause in Section 60, subsection 5 is designed for a different purpose, to ensure that NCLT alone has the jurisdiction when it comes to the application and proceedings by or against corporate debtor covered by the code. London NCLT was certainly having jurisdiction to entertain an application for defreezing the aforesaid demat accounts. So this is a fabulous judgment. And this involves actually three sections: Section 14, Section 60, subsection 5, and Section 238. And we should keep it in mind. And this is an excellent read. Please go through the excerpts of the judgment featuring on the website. It will give you a lot of learning. With this, we move on to the next slide. We are on the screen of Regulation 36, which deals with information memorandum. And the topic which we are going to deal with is topic number 3, which says that the word contingent liability has been added in Regulation 36(2)(a). However, the word contingent asset has not been mentioned anywhere, which is true. Let us go to Section 31. This particular case which we are going to deal with is an exception of exceptions. So it also has a topic, associates a new topic in Section 31, which says that contingent asset discovered later by SRA post approval of the resolution plan should never become the property of the corporate debtor, and should not be returned to the erstwhile members of COC. Right? What is the case? Case is SPS Steel Rolling Mills Limited versus Central Bank of India, Company Appeal so-and-so of NCLAT. In this particular case, it's a long judgment. It's a wonderful judgment. What happened was the plan had got approved. The management of the CD was already taken over. And post taking over, they found that there were different fixed deposits which were given to the bank on account of margin money for various LCs opened. Now the LCs were not, had not matured, or LCs were not operated, so the margin money remained with the bank. And they were later discovered. And this was automatically, since margin money was not utilized, this became the asset of the corporate debtor. So a question arose as to whom does it go? To the COC or to the SRA? So on that, this judgment is based on only that factor, and which is an excellent. So This margin money was not featuring in the information memorandum. So this is a contingent asset, not a contingent liability. And in 36, there is no mention. And the second question is the resolution plan had already been implemented. So there were two aspects. So based on which NCLT dealt on this. So in order to make the thing short and precise, let me take you over to the slide which I prepared for you. Since I've already read the two topics, I'm not going into the same. Now, what the basic takeaways from the judgment is that the FDR of corporate debtor, SPS Steel Rolling Mills Limited, were made in lieu of margin money for bank guarantees, issued by Indian Overseas Bank, Central Bank of India, and others during 2005, 2013, 2012, 2014, respectively. All BGs expired between 2009 to 2017. And the said FDR of the corporate debtor were not part of the information memorandum, as I told you. The Shakambari Ispat Private Limited, the SRA, who has implemented the resolution plan, paid the due amount to the final settlement of all claims, took over the assets of the management of the corporate debtor. If the bank guarantee expires without being invoked, then the margin money reverts back to the borrower. And in case the bank guarantee is invoked by the beneficiary, the margin money goes towards the payment of the bank guarantee or to the beneficiary. You know that. Now, the adjudicating authority held that the appellant is not entitled to get the proceeds of the FDR in line with the respondent bank. The adjudicating authority further held that the amount of the appellant has already been received from Indian Overseas Bank, that is 79,24,041, will have to be refunded by appellant along with interest applicable to the FDR. The matter went to NCLAT. NCLT held that information memorandum is to make prospective resolution applicant aware about the financial health along with operational environment of the corporate debtor so that the prospective resolution applicant can submit resolution plan accordingly. The word contingent as liability has been added in regulation 36(2)(a). However, the word contingent asset has not been mentioned anywhere. The contingent asset are possible asset arising from past events whose existence may be confirmed at a later date by uncertain future events. Contingent means that its evolution arises out of uncertain future events. When bank guarantee were required, these FDR were treated as margin money. Typically, the FDR should have been when considered by RP, but it was not. It cannot be the case that the asset discovered by the SRA post approval of the resolution plan should never become the property of the corporate debtor and should be returned to the erstwhile members of COC. It can never. How? The erstwhile members of the COC have been paid in full settlement of their dues. So they cannot claim it anymore. They cannot claim it anymore. The respondent bank have no right to adjust such balance after resolution plan has been fully implemented. So this belongs to the SRA. With this, we move on to the next slide. We are on the screen of Section 29A. Section 29A of Insolvency Bankruptcy Code essentially defines persons who are not eligible to be resolution applicants. There are multiple, but before going into our basic focus is 29, two subsections of Section 29A. So let us look into those first. 29A C. At the time of submission of the resolution plan has an account or account of a corporate debtor under the management and control of such person or of whom such person is a promoter, classified as a non-performing asset in accordance with the guidelines of the Reserve Bank of India issued under Banking Regulation Act to 1949 or the guidelines of a financial sector regulator issued under any other law for the time being in force and at least a period of 1 year has elapsed from the date of such classification till the date of commencement of corporate insolvency resolution process of the corporate debtor. That means 1 year should elapse in between, at least 1 year. From the date the NPA was declared of the company for whose resolution plan is being submitted, and the commencement of corporate insolvency resolution process of the company for which the resolution plan is being submitted. So 1 year should elapse. And the criteria is what? In declaration of NPA. Now we come to E. E says what? Is disqualified to act as a director under Companies Act 2013, provided that this clause shall not apply in relation to a connected person referred to in clause 3 of exception I. Okay, clause 3 is, I don't see, so it has been removed. Okay, right. So let us go to section 29A. Topic number 31. The language of section 29AC links ineligibility to the existence of a financial default leading to NPA classification. And the same for 29AE indicates that a disqualification must already exist in law. It cannot be presumed or inferred that the director is ineligible. The cases of Malhar Shanti Enterprises versus Naresh Sevantilal Shah and another, Company Appeal so and so of 2025. In this particular case, a person, a PRA whose plan was not approved, complained that the SRA, that is successful resolution applicant's plan was approved without noticing defaults from the point of view of 29AC and 29E of section 29A. And the case is very interesting, no doubt. The court determined basically two aspects: whether the unsuccessful resolution applicant had a locus to complain, and secondly, whether there was truly ineligibility was there or not. So both aspects were looked into, and various cases were referred to. This is a very interesting read. It also mentioned about section 164 of Companies Act. So I would strongly recommend my viewers to go through this. Well, let me take you to, for more precise understanding, let me take you to the slide which I've prepared for you. Now, this does not confine to one topic only. You will find this in section 31 also, in topic number 129. What does the topic say? Once a resolution plan has been fully implemented and the management of the corporate debtor has changed hands, the settled position of law is that such a plan cannot ordinarily be unsettled or unscrambled at a belated stage. So plan approval once done completely and management handed over, you cannot unsettle it or unscramble it at a belated stage. So first, as I said, the court looked into the aspect of whether the person is really aggrieved or whether he can move a petition under section 61 of Insolvency Bankruptcy Code, which deals with appeal to NCLAT. The right to prefer an appeal under section 61 of IBC is conferred upon a person aggrieved. So what is to be looked is whether a person is aggrieved or not. The expression person aggrieved implies that the impugned order must directly affect the legal rights or interests of the person invoking the appellate jurisdiction. However, a person aggrieved has to be a stakeholder in the CIRP process. Where this was held? This was held in Glass Trust case. Glass Trust versus Baju Ravindra. The appellant was not a financial or operational creditor. Probable resolution, he was a probable resolution applicant, resolution professional, or any other participant in the CIRP process who could be classified as a stakeholder in the CIRP process of Afghan Impex Private Limited. Plus, he cannot be considered as person aggrieved in accordance with 61 of Code. So the Code, so NCLT could have just simply set aside the appeal on this ground itself. The person did not have a locus, but still then it looked into the merits of the case. 29 AC requires that a person concerned must have an account classified as an NPA in accordance with the guidelines of Reserve Bank of India. Such default must remain unpaid and for the prescribed period. Prescribed period is what? At least 1 year. The language of the provision clearly links ineligibility to the existence of financial default leading to NPA classification. The account of CAN Enterprises was not qualified as NPA, and disqualification contemplated under 29 AC cannot be attracted merely on the basis of pendency of CIRP against another entity. So this is not applicable. This account was never declared as an NPA. So 29 AC does not apply. As simple as that. It has to be, just because CIRP is instituted doesn't mean the company is supposed to be an NPA account. 29E specifically refers to a person who is disqualified to act as a director under Companies Act 2013. The language of the provision indicates that the disqualification must already exist in law. It cannot be presumed or inferred. 29E for 29AE to apply, such disqualification is determined and declared by the competent statutory authority, namely Register of Companies, ROC or MC, etc. In the present case, applicant did not raise any objection before the adjudicating authority in the CIRP proceedings of Afghan Impex Limited, which continued from 2001 to 2025. Therefore, appellant cannot now seek to raise fresh issues first time in the appellate tribunal. So firstly, what? To declare a person ineligible under 29AE, such thing cannot be presumed. There has to be an order from ROC or MC or from any other body. And that's just because is held as ineligible, you cannot hold it. So once the resolution plan is fully implemented and the management, and then lastly the court held that once the plan is fully implemented, the management of the debtor has changed hands. The settled position of law is that such a person cannot ordinarily be unsettled or unscrambled at a belated stage. You cannot do that. It goes against Ghanshyam Mishra. But Ghanshyam Mishra did not deal with this. It essentially dealt with payment, liabilities. But this is very important. This is very, very important case. So with this, I move on to the next slide.
Viewers, we have come to the halfway of the presentation. Please note that the bill on Insolvency Bankruptcy Code was approved by Parliament of India. And very soon we are going to get Insolvency Bankruptcy Code with a lot of new sections and regulations with a lot of amendments. So many things are going to change. But having said that, the old cases will remain there and they will be equally important also. So let us see when these are introduced. But in the meanwhile, let us continue with the podcast and hope you will enjoy it.
We are still on the screen of section 31. We are coming to a new topic, which says that is topic number 112, which says that any claim which is not expressly included in the resolution plan and which is not expressly barred as per such plan cannot be inferred to have been included therein. Topic number 111 says what? All such claims which are not a part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect of a claim which is not a part of the resolution plan, which is Ghanshyam Mishra judgment of Supreme Court. Now, this is a little bit different. Not little bit, to a great extent different. Any claim which is not expressly included in the resolution plan and which is not expressly barred as per such plan cannot be inferred to have been included therein. So the difference is understood. The plan which is an item which is not included, but is not barred also. So it cannot be inferred to be included. This is case of very recent Supreme Court case in the matter of Ujas Energy Limited versus West Bengal Power Development Corporation Limited, civil appeal number so arising out of SLP number so 2024. Now, in this, what happened was Ujas Energy was a power supplier. They had an agreement with WBDCL. Now, Ujas Energy went into CIRP. WBDCL, West Bengal Power Development, they submitted a claim, and Ujas Energy spoke about a counter claim. Now, there was an arbitration proceeding going on which had to stop because of Section 14 of Insolvency Bankruptcy Code. That is moratorium. Now, the question came, and the counterclaim never came into the knowledge of the RP also. Now, the question came, what happens post-CIRP? So, the Supreme Court has dealt in depth on the subject. They have analyzed Section 31. They have gone through Ghanshyam Mishra judgment and other judgments and formulated their views. This is an interestingly, being a Supreme Court judgment, I need not reiterate that it should be, the excerpts of the judgment which is featuring in the website should be thoroughly read and understood. With this, I stop the screen share and take you to the slide which I prepared for you. Court has inferred that CIRP is a time-bound, credit-driven statutory mechanism incorporated under IBC to resolve corporate distress of a corporate debtor, which is a going concern. In terms of Section 31(1), the effect of the provision is that the plan's terms are binding as they stand, and it attaches finality to the resolution plan. Terms of the plan are to be read strictly given its binding nature and extinguishment of claims not part of it, which aligns with the resolution objectives of IBC. That is the reason why it is called a binding resolution plan, because the terms of which are binding by nature, and it extinguishes claims which are not part of the resolution plan itself. The respondent's claim raised by way of counterclaim before tribunal does not find a place in the resolution plan. Hence, stands extinguished. WBDCL, West Bengal Power Development Corporation's counterclaim is not a part of IM. And it's not an accepted claim either. So, in such case, it stands extinguished. There's no doubt about that. The resolution plan does not appear to bar a plea of set-off being raised as a defense in any pending arbitral proceedings, although claims for any payment or settlement, including a counterclaim not included therein, is specifically not recoverable. So the resolution plan, the court here read a paragraph of the resolution plan and said the resolution plan does not appear to bar a plea of set-off raised as a defense. The word defense has a tremendous meaning here. In any pending arbitral proceedings, although the claims of any payment or settlement, including counterclaim not included therein, is specifically not recoverable. Any claim which is not expressly included in the resolution plan and which is not expressly barred by such plan cannot be inferred to have been included therein. There is no question of inference in a resolution plan. The respondent, although not entitled to independently pursue its claim by way of counterclaim post approval of the resolution plan, ought to be permitted to raise the plea of set-off, at least by way of defense. In case the claim is taken up, counterclaim is taken up in arbitral proceedings, then in such case, Supreme Court is allowing it to take it up as a defense, not as the main clause, as a defense only. The respondent shall not derive any positive or affirmative relief on the basis of the same defense and may only defend itself against the claim raised by the appellant. So if the appellant raises the claim, then in defense of that, WBC DCCL can raise this point and defend itself. We are on the screen of Schedule 1 of liquidation regulations, which deals with mode of sale. Let us come to topic 63, if I'm not wrong. Yeah. It says that forfeiture of amount paid by unsuccessful bidder, if resulting in unjust enrichment in the hands of the liquidator, cannot be allowed. This kind of topic we are coming up for the first time. Forfeiture of amount paid by unsuccessful bidder, if resulting in unjust enrichment in the hands of the liquidator, cannot be allowed. The cases of Xylocopa Builders and Developers Private Limited versus Namrata Amol Randeni, liquidator in company appeal so and so of 2025. The cases here, this is usual case. An asset was being auctioned by the liquidator. The bidder, the successful bidder, initially paid the EMD amount and later paid the deposit which was required. But then later on, despite doing, I don't know whether the due diligence was done properly or not, he raised a question of lien and liquidator also. And in the course of, because caveat emptor applies in the case of auction, so the liquidator in due course of time cancelled the sale, returned him, and then thereafter he auctioned again and sold it to another bidder. The question came as to whether how much money he should retain and how much money he should return. So the matter was extensively dealt with by NCLAT. It was divided into three. Basically, NCLT divided its inquiry on three topics: whether auction of the liquidator cancelling the 9th e-auction by email 14/9/2024 is in accordance with law and has rightly been upheld in accordance with the e-auction process memorandum. Question number 2, whether in facts of the present case, forfeiture of 25% amount posited by the appellant in pursuance of the auction held on 19/4/2024 is justified. What is the consequence and effect of the auction sale property in favor of another successful auction purchaser for same amount of rupees 81 crore held on 2/5/25. The NCLT gave the judgment in basically parts, in two parts, question number 1, question number 2 and 3 together. This is an interesting read and important judgment. I would request my viewers to please go through the judgment, excerpts of the judgment on the website. Now let me take you over to the slide which I prepared for you. Process memorandum clearly contemplated bidders should conduct their own investigation and analysis and should check the accuracy and correctness of the statement of information contained in the process memorandum, which all liquidators do. And it is the duty. As I said, rule of caveat emptor applies in case of auction sale. The appellant was declared auction purchaser, successful auction purchaser on 19/4/2024 for an amount of 81 crores. The appellant deposited EMD of 4.05 crores and further sum totaling 25%, that is 20.25 crores. Done. There was a charge of the excise department of the assets of the corporator during title search. The encumbrance of excise department was noticed and communicated by the bank. On 14/9/2024, the liquidator has issued email to the appellant for cancellation of the sale and forfeiture of the amount deposited by the successful bidder. On 6/2/2024, Adjudicating authority directed successful buyer and appellant to send a copy of the order of 33,125 to the bank, and the bank to release the amount within 3 working days from the date of deletion of lien on the revenue records. So the adjudicating authority thus till the time had granted opportunity to the appellant to ensure that the balance amount is paid. So though liquidator had cancelled, adjudicating authority allowed sometimes some respite that the lien is lifted, you pay. After the appellant having participated in the bidding process cannot be heard by saying that the payment of the balance sale consideration was linked with the lifting of the attachment order. Liquidation process as per IBBI Liquidation Process Regulation 2026 is a time-bound process and in event of successful auction purchaser has not complied with the payment terms. The liquidator was fully competent to cancel the e-auction in favor of the appellant and proceed for fresh auction. As I said, this is the auction purchaser is supposed to be aware of everything. He should have considered, he should have known that there is a lien in existence. Nobody stopped him, nobody forced him to bid. But once he bids, he cannot say that the lien was there, this was there, that was not there. It is not permissible. So the liquidator was fully justified in cancelling the sale, despite the fact that later on, subsequent to liquidator cancelling the sale, the adjudicating authority ordered excise department to remove the lien. And it was done. But then also the money was not paid. Now, no exception can be taken to the order of the liquidator in cancelling the sale and forfeiting the EMD. But the question was the 16 point. Initially, they paid 4.05 and then 16.15 or 16.20 crores towards 25%. So 4.05 was the EMD amount which was returned, but question came as to 16.20 crore. The amount of 16.20 crore which was deposited on 9/5/2023 would be permitted to be refunded to the appellant due to the reason that in the subsequent e-auction asset was sold by the liquidator for the same amount of rupees 81 crores. He was selling to this auction purchaser at 81 crores. And he's again selling it to another person at 81 crores. So his proceeds, what he was supposed to get, he's getting that. So this 16.20 crore, if it remains with the liquidator, then it becomes an unjust enrichment. So permitting the amount of rupees 16.20 crore to remain with the liquidator shall clearly be unjust enrichment in the hands of the liquidator. And hence this should be returned back to their unsuccessful return. So this is a beautiful thing this is absolutely new, and this is absolutely a new topic, and everyone should keep a note of this. With this, we move on to the next slide. Here on the screen of Section 65 of the Code, which deals with fraudulent or malicious initiation of proceedings. Insolvency proceedings, that means. Now, at times, when we do this podcast or when I'm recording the judgments, I reckon how intelligent we human beings are. In the course of so many years of being an insolvency professional, the kind of litigations, the kind of topics, we have more than 5,000 topics now. I mean, more than God knows how many topics we have on the website. It keeps on piling up. And it shows the variety of thinking process human being can conceive. And that is why new topics are coming up. So basically a case is what? A difference of opinion. Difference of opinion arises of the way of thinking of people. And so people think differently in every case. And that is how cases take place and how complications arise. Now, anyway, here we are coming with we know this topic. We have dealt with this topic earlier. If there is fraud, it will vitiate everything, including the order approving the resolution plan. Thus, the stage of CIRP is inconsequential while considering Section 65 application. This case is of Gopal Trading Company versus Mr. Ravi Kumar Goel, RP, and others. Company appeal so and so of 2026. It's a very recent case, goes without saying. In this case, what happened was this is a 665 case in which this is a radically good 65, but this case has got twists and turns which are really worth noting. Here, this was a Section 9 petition, which was, and the applicant never filed the claim. So that was the first contention as to why Section 65 was. And Section 65 was initiated, when it can be initiated, how it can be initiated, what authority adjudicating authority has. These are all the questions which are answered in this particular case. And in this case, besides appellant not filing the claim, he was also found to be a ex-director of the company, brother of the director of the company. The basic motto was to not to pay GST or income tax or whatever it is. So on this entire cases, so it's a very interesting read. And I would request all my viewers to go through the excerpts of the judgment you will find on the website. So with this, I take you over to the slide which I prepared for you. In the order impugned, it was held that the CIB proceeding had been initiated fraudulently and or with malicious intent for the purpose other than insolvency resolution of the applicant. Besides that, the court imposed a penalty of 10 lakhs and fastening fees of the RP and CRP cost amounting to 6 lakhs on the appellant. So 10 lakhs penalty plus 6 lakhs cost on account of CRP expenses was put on the appellant. The RP had filed IA number so and so with a prayer, which clearly made that the CRP initiation was done fraudulently and maliciously initiated, other than the purpose of resolution of corporate debtor. It is undisputed fact that the appellant had been impleaded as a party therein and therefore afforded an opportunity to appear before adjudicating authority. The adjudicating authority is well within his right to take a suo motu cognizance of any such development at any stage of the proceedings. Means what? This particular headline is tremendously important. The adjudicating authority is well within its right to take suo motu cognizance. The adjudicating authority is well within its rights to take suo motu cognizance of any such development at any stage of the proceedings. That means based on the IA or anything, a suo motu cognizance can be taken by adjudicating authority. He doesn't even need an IA. He can do it on his own. Seeing you can present a petition under section 30 subsection 6 and the NCLT can say that no, I'll take section 65 because this appears to be a section 65 matter. The CIP is initiated with malicious intent. So he can take suo motu cognizance also. So this sentence is tremendously important. The appellant had filed section 9 application on the basis of outstanding of operational debt of 3.80 crore. However, post-CIP surprisingly slipped into hibernation mode and did not file any claim in pursuance of public announcement made by RP. So think of it. This guy institutes CIRP. He takes all the trouble. And he does not submit a claim. And it is not a small amount. It's 3.8 crores. The only claim filed in the CIP process was two entities, Assistant Commissioner of GST and Assistant Commissioner of State Tax, which were authorized to collect statutory taxes. The adjudicating authority has therefore rightly noticed that the intention of CIP followed by moratorium barrier coming into existence under Section 14 coincided with pending recovery actions of tax departments. So what was the purpose of CIRP? It was so that Section 14 moratorium comes, the tax authorities or the revenue authorities cannot recover the money. That was the sole objective. And that is the reason why they did not file the claim. The issue of legal notice, lodging a police complaint, appellant shows that the appellant was meticulously preparing for the legal battle they had chosen not to enter into. They had filed a police complaint and all that, but did not file a claim. So they were fully prepared. Adjudicating authority has further noticed that the appellant was related to the director of the corporate debtor and that his familial relationship was extremely close relationship as they were real brothers and the appellant was also an ex-director of the corporate debtor. What more do you want? He is an ex-director of the company and brother of the main director of the corporate debtor. So he knew about it, filed a Section 9 petition, thereafter filed a police complaint, and so that the entire purpose was not to pay GST and the sales tax. Thus, non-pursuit of the claims arising out of debt owed by the corporate debtor clearly establishes that the purpose was not resolution of the insolvency, but to prevent recovery proceedings of CGST and GST department. The adjudicating authority in the present factual matrix cannot be said to have faulted in exercising its residuary jurisdiction to hold that the fees and expenses of the RP shall be borne by the appellant and being the original operational creditor. And also, not to forget, the rupees 10 lakh fine. And that the CRP proceeding is quashed. So this is a very, very important judgment. Very important judgment. And is an exceptional one too. So with this, we take you over to the next slide. We are on the screen of Section 95 of Insolvency Bankruptcy Code. Section 95 deals with what? Application by creditor to initiate insolvency resolution process against an individual. Right now, individual is not there, against a personal guarantor. Now, what does the topic say? Acknowledgement whether by borrower or by guarantor has the effect of extending limitation under Section 18 of the Limitation Act. The case we are going to deal with is Phoenix ARC Private Limited versus Mr. Rajendra Himmatlal Salot, Company Appeal so-and-so of 2024. The case came out very recently. In this, what happened was the 13-2 notice was issued of the company as well as the personal guarantors on 12th of April 2018. The SEBI proceedings were going on. The first notice under Rule 7.1 of Personal Guarantee Rules was issued on 23/9/2022 and thereafter on 6/4/2023. Now a question came whether this was barred by limitation or not. So it's quite a long judgment, and this is a number of case laws have been mentioned in this. So let me take you over to the slide, which will help you understand the case better. This is nearly about a 45-page judgment of 24th March 2026. The appellant, original lender, on 12th April 2018, had issued demand notice under 13.2 of SEBI Act on the corporate debtor, as well directors and the personal guarantors. The notice was issued, personal guarantors. Now, the court gave them 60 days time because the notice mentioned that within 60 days to pay. The personal guarantors committed default in their obligation under guarantee expiring after 60 days from the date of receipt of the notice dated 12/4/2018 as per SEBI Act. Accordingly, the personal guarantors committed default as on 16/6/2018. Hence, proceeding under SEBI Act and proceeding under IBC Code are independent proceedings and can run concurrently, and there is no bar holding the proceedings against personal guarantors, even if the personal guarantor was prosecuted under SEBI Act. This is very important. So you can have parallel proceedings in SEBI as well as IBC. Notice issued under Rule 7.1 of the personal guarantor rules overrides invocation of any other guarantee, and the appellant could not have relied on the mechanism of SURFACE Act while pursuing remedies under IBC Code. 7.1 rule, the notice issued on 23/9/22, has an overriding effect, and it cannot be ignored. So taking the plea of SURFACE was not sufficient. The independent auditor's report dated 31/12/2020 of corporate debtor, Mrs. Raj Poly Products Limited, had acknowledged the debt against the bank Janata Sahakari Cooperative Bank, which was assigned to the appellant. So on 31/12/2020, this was acknowledged as far as the principal borrower is concerned. Any acknowledgement made by the principal borrower would be deemed to be an acknowledgement made by the guarantors. Adjudicating authority mentioned the existence of the independent auditor's report in the impugned order, but failed to take the same into consideration while calculating the period of limitation. What happened in between, if you think of it, from 2020, February 2020, a COVID period started. And as we know, we have come across this, that the entire period of COVID period has to be ignored. So this adjudicating authority did not. The limitation restarts. The limitation restarts for personal guarantor from the date of acknowledgement of CD's books of accounts. So when 31/12/2020, it was acknowledged, you get into account the COVID period. So the limitation would not expire on 29/5/2022 as held by the adjudicating authority. 3 years starting from 1/3/2022 would expire on 1/3/2025. Accordingly, we find this petition not barred by limitation and deserves to be entertained. And the matter was remitted back to NCLT. So this is an interesting read. This is a good judgment, and please go through it. Go through the excerpts of it on the Guide to IBC website. We are on the screen or on the dashboard of Section 96 of Insolvency Bankruptcy Code, which deals with interim moratoria in individual and partnership insolvency process. Now, we know that individual insolvency is restricted to personal guarantors. We are coming to a case or a topic, rather a case, which outwardly looks very simple, but it has many twists. So the topic which we are coming to is topic number 19, which says that the statutory interim moratorium, which triggered in Section 96, shall come to an end only when application under Section 95 is either rejected or admitted. Understood? Sounds very simple. Now, let us see the case. Case is Sushant Chabra versus Catalyst Trusteeship Limited and another company appealed so and so, 2026, I suppose. Yes, 2026. Now you can see the case here. The case in brief is very simple. Canara Bank filed a Section 95 petition for invoking personal insolvency on a personal guarantor. Later, Catalyst Trusteeship Limited, which is also a financial creditor, filed another petition for under Section 95 for instituting personal insolvency. That was after Canara Bank. Now later, Canara Bank withdrew their petition, and NCLT considered the petition of Catalyst Trusteeship Limited and admitted the personal guarantee to personal insolvency process under Section 100 of Insolvency and Bankruptcy Code. The personal guarantor challenged the order and went to NCLAT. That's the nutshell. Please go through this because this has isme bahut twist hai. So there are many twists in this particular thing, and I think this is this is one of the best 96 judgment, Section 96 judgment that I've come across. So I would strongly recommend all to go through this. Now, let me stop the screen share. Let me stop the screen share here and take you to the slide which I prepared for you. Now, what does the court say? On filing of Section 95 application by Canara Bank, the interim moratorium was triggered on 12/1/2025. We know that as soon as the petition is filed, it is numbered, the interim moratorium starts. So the interim moratorium started on 12/1/2025. On the date Catalyst Trusteeship filed this application, that is on 5/8/25, interim moratorium was in operation. No doubt about that. When the insolvency resolution process commences against the personal guarantor, all creditors in the personal guarantor are taken care of in the proceedings under Section 90 under Chapter 3. Due to embargo under Section 95, subsequent application filed by financial creditor gets dismissed since personal insolvency has already commenced, which was pending consideration. Because interim moratorium was in place. So automatically it does not allow another financial creditor or any creditor to come forward and file another petition under 94 or 95 because Section 95 petition is already under consideration. So the financial creditor, the Catalyst Trusteeship, whatever petition they had filed, it was ought to be dismissed. The effect of withdrawal of suit is that the parties are left in the same position which they had occupied if no suit had instituted. The withdrawal of suit has no existence in the eye of law. Which when a case is withdrawn, it comes back to square one, as if the place where there was no suit filed. So withdrawal of suit has got no existence in the eye of law. So on the day the personal insolvency was, the petition of Section 95 was withdrawn by Canara Bank, the things came back to square one. Although on the date Section 95 application was filed by Catalyst Trusteeship against the appellant on 5/8/25, interim moratorium was already operating in Section 95 application of Canara Bank, filed by Canara Bank by the applicant. The statutory moratorium, which was triggered on 12/1/25, continued to operate till 10/11/25. That is the date when application filed by Canara Bank was withdrawn. So the interim moratorium started on 12/1/2025 to 10/11/2025, till the date Canara Bank withdrew its application. The statutory interim moratorium, which triggered in Section 96, shall come to an end only when an application under Section 95 is either rejected or admitted. During the period when interim moratorium is operating, any initiation of proceedings shall be non-est in law. Thus, proceeding which was initiated by financial creditor during currency of interim moratorium was non-est from the very beginning and cannot become a legal proceeding after interim moratorium is withdrawn on 10/11/25. That means the petition filed by Catalyst had become non-est. It too had become non-est because since interim moratorium was in place. So the order of adjudicating authority admitting Section 95 application cannot be sustained. The impugned order of 17/2/2026 is set aside. A petition which is non-est cannot be considered. The 95 application filed by Catalyst Trusteeship are dismissed. The financial creditor is to file fresh application under Section 95 in accordance with law. Which was if Catalyst Trusteeship still wants to institute personal insolvency against the personal guarantor, it has to file a fresh application. Not the old application cannot stand because it was non-est in law. So this is a wonderful twist. And this should be noted, and we should all know about this. And that is why I have selected this case for as an exceptional case, which we should all note. With this, we move on to the next slide. Here on the dashboard of corporate insolvency. And we are coming to the chapter of personal guarantors. As we know, personal guarantors is segregated in two parts. One is insolvency and another is bankruptcy. We have had number of insolvency cases, but bankruptcy is new, relatively new, because those who are in insolvency will now gradually go into bankruptcy. and cases will multiply now. So in bankruptcy, we have two things. One is bankruptcy rules and bankruptcy regulations. Our concern is Regulation 30. Regulation 30 deals with valuation of assets. Valuation of assets says what? One, bankruptcy trustee shall appoint a registered valuer to value the assets which may or may not form part of the bankruptcy estate when he is of the opinion that it is necessary or when a resolution to that effect has been passed by the committee. Two, registered valuer appointed under subsection 1, subregulation 1, shall submit to the bankruptcy trustee the estimate of a realizable value of the asset computed in accordance with such valuation standards as notified by board through circular after physical verification of the asset of the bankrupt. 3. Bankruptcy trustee may appoint additional registered valuer for valuing the asset of the bankrupt if required in the circumstances of the case, who shall independently submit his report under subregulation 2. 4. In the event of additional registered valuer is appointed under subregulation 3, the average estimate of receipt from both valuers will be considered for the valuation of assets. 5. For the purposes of this regulation, a registered valuer shall prepare the valuation report and maintain such documentation as per the format notified by the board through circular. So we have understood what the valuation comprises of. This I'm reading because valuation in bankruptcy is new subject to all of us. Now the case we are coming to has the heading or the topic reads as, in specific case of bankruptcy of personal guarantors of corporate debtors under IBC, the power of DRT has been vested in NCLT. So the adjudicating authority in such case has to apply the norms followed by DRT. Let me read it out again. In the specific case of bankruptcy of personal guarantors of corporate debtors under IBC, the power of DRT has been vested in NCLT. So adjudicating authority in such cases has to apply the norms as followed by DRT. Case is Akshat Gupta versus Union Bank of India and others, company appeal number so 2024. It's a very recent case. Now in this case, this is a long judgment. And the headlines are also, because this is a new thing, you have to understand, the headline should speak for itself. In this case, what happened was an asset was auctioned by the bankruptcy trustee. Union Bank of India held 97.27% stake in the committee of creditors. They had exalted position in the committee of creditors. They complained to NCLT that the auction had taken place, undervalued auction had taken place, and they wanted the valuation to be set aside, which NCLT complied with. Obviously, the auction purchaser went to challenge the order of the NCLT and went to NCLAT. NCLAT upheld the decision of NCLT due to multiple reasons, which are elaborated in the excerpts of the judgment. If you go through it, you will understand. I would strongly recommend, but in order to make things short and precise and understandable, let me take you over to the slide which I prepared for you. As mentioned to you earlier, Union Bank of India held 97.27% vote share. The valuation of the assets was conducted by the bankruptcy trustee prior to formation of COC. When he shared the valuation, post it was after COC was formed. And so the post facto sharing of valuation deprives COC of the opportunity to participate meaningfully at the valuation and consequently auction planning stages. The bankruptcy trustee, by keeping COC out of the loop, reinforced tribunal's conclusion that the sale proceeds did not fully meet the standards of the fairness of value maximization mandated under the court, because he did not keep COC involved in it. The valuation was done on its prior to formation of COC. So, and the valuation and the auction took place based on the valuation. So, since COC was not there, and the valuation involved in the valuation process, so the fairness was not there, and so the value maximization couldn't have possibly taken place. It was an arbitrary thing. The figures clearly show a wide variation in the valuation of the property over time, ranging from 2.75 crores in 2016, 3.82 crores in 2021, and an approximate present market value of 4.5 crores in 2023. This auction took place in 2023. The bankruptcy has taken drastically a lower valuation of only 0.90 crore for 50% of the property as determined by the registered valuer in 2023. The valuation of full property would be 1.80 crore. So where is 4.5 crores and where is 1.8 crore? And this property which was being sold is 50% of a residential. So obviously this wasn't done properly. The regulation 30.3 of bankruptcy trustee can obtain valuation of more than one valuer's report. Essentially to ensure fair assessment of asset. Despite being aware that the entire property was mortgaged in favor of Union Bank of India, respondent one, that is bankruptcy trustee, proceeded with the valuation and sale without consulting the bank or seeking directions of adjudicating authority. This was absolutely wrong. The fact that the property was encumbered and 50% share of the property was in the name of Mrs. Meenakshi Sial, wife of bankrupt, and the SARFAESI proceeding was ongoing against both should have been highlighted in the auction notice. So a flat in which 50% owned by the husband and 50% owned by the wife. Bankruptcy proceeding is going against the husband. But whereas 50% on 50%, which is a portion which belongs to the wife, SARFAESI proceeding is going on. So both the properties are mortgaged to Union Bank. So the auction purchaser should have known about it. And it should have been mentioned in the auction notice. And the process memorandum, which was not done. Non-sharing of valuation prevented the bank from examining or questioning the valuation and adversely affected transparency and fairness of the sale process. Respondent 2 failed to comply with Regulation 8, Sub-Regulation 3B4, which requires bankruptcy trustee to place all relevant and material facts before the adjudicating authority, which wasn't done, as I mentioned earlier. In the case of personal bankruptcy, entire process is dealt by Debt Recovery Tribunal, that is DRT, under SARFAESI Act, which provides for a notice period of 30 days for auction. Herein, the bankruptcy trustee provided 25 days notice. Now, originally in insolvency of personal guarantors is supposed to have been, the adjudicating authority was supposed to be DRT. Since personal guarantor was included, it was included in section 60 and said that NCLT will hold the jurisdiction. But in cases like auction, which is not very much elaborated, the bankruptcy trustee should follow the DRT norms. I mean, at least the guidelines of that. So that's why the court says that the Debt Recovery Tribunal, the auction purchase, the bankruptcy trustee should follow the norms of SARFAESI and should have provided 30 days notice. In this specific case, bankruptcy of personal guarantors, corporate debtor under IBC, the power of DRT has been exercised. So the adjudicating authority in such case should apply the norms followed by DRT. The findings of adjudicating authority that the auction process did not provide sufficient opportunity for fair market participation and value discovery is fully endorsed. So, the court NCLAT agreed that undervalued sale had taken place and the auction was set aside. So, this is something absolutely new, and I would strongly recommend my viewers to go through the excerpts of the judgment on the website, and as well as if you want a copy of the slide, you can always ask for it. You're most welcome to do so. With this, we move on to the next slide.
Viewers, we have come to the end of our podcast. Hope you liked it. Please share your views, comments, and likes on the presentation, because those things motivate us to create the podcast and to develop our quality. Even criticism are most welcome. Guide to IBC is not my website. This website is dedicated to all citizens of India, and it is hoped we have created this website with a view that everyone learns about this dynamic code, which will take India to new heights of glory in terms of revival of financially distressed units. Bye for now.